Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we're going to talk a little bit more about some areas of the K3 visa. Now, I've got some other videos on, the difference between the K1 and the K3 and some general type information, but I'd like to get into a little bit more detail with this particular visa. Now, what is the K3? Well, the K3, for all intents and purposes, is when a person goes outside the country, wherever they happen to go, and marries their loved one, and they then have a spouse. And rather than waiting for the consulate processing, which is the normal procedure for someone to come in on an immigrant visa, the K3 supposedly is a lot faster. They will be able to come in, and then once they're in the U.S. on a K3, then they can apply for adjustment of status. So that's the basics for the K3. Now, there's a couple issues that you need to be well aware of. If you come in on a K3, the only way you're going to adjust status is through the person who petitioned you, which is your spouse. If you come in on the K3 and whatever happens, you get divorced, things don't work out, whatever it is, and let's just say you get married again and try to file for another adjustment of status, that will not work. You will not be able to do that. In that particular case, you might go all the way to the interview. You might have your work permit, think everything's hunky-dory, and then at the interview they find out you entered on a K3, that the petitioner is not your spouse, and they will deny the adjustment. You could be put in deportation proceedings, but at a minimum, you're not going to be able to adjust. So what do you do in a case where you have come in on the K3 and again, for whatever reason, it didn't work out and you didn't get your green card through the petitioner? It even might go so far as you might have gotten the conditional green card, but you didn't file the petition to remove the conditional residency, again, because things didn't work out, and therefore you're left without status. So what do you do? And let's assume that you're married again and you mistakenly tried to file adjustment through your spouse. Well, the way that it would work, especially in today's day and age where the new provisional waiver law is out, is if you come into my office, first I'll find out if you're inadmissible on any other grounds. I'll see if you have any criminal history, deportation orders, fraud, and assuming you don't have any of that, I'd want to go in and make sure that the initial K3, that it was a bona fide marriage. So, obviously, if you knew the person for, 3 days, got married, came to the U.S., and then divorced a month and a half later, that's going to be very difficult to prove that it's a bona fide marriage. So again, we get past that issue because once there's a issue with the bona fide marriage of the first K3, then it doesn't matter how many times you marry. After that, you're not going to be able to adjust if immigration adjudicates that you have committed marriage fraud. So assuming that there's no marriage fraud, that it's just the marriage didn't work out, and assuming you're not inadmissible on any other ground, then the way it would work is your spouse will do consulate processing and a provisional waiver. Because let's assume that you've been out of status. I mean, if you haven't been out of status and for a sufficient period of time and you're not subject to the 10-year bar, or the 3-year bar, well, then get out of the country and do consulate processing, and then you don't have to even do a waiver. But assuming that you are, which is probably the case, because if you got divorced, you got married again, there's sufficient time, at least 6 months to a year has passed that you probably have been out of status. So, again, I would also determine whether you are actually subject to the 10-year bar. And then we would do the provisional waiver here in the United States, plus the consulate processing. Make sure everything would get approved, meaning that we could show sufficient hardship to your spouse and so forth. And then assuming the provisional waiver was approved, then you would leave the country go back to your home country for the interview. You would be gone for a very short period of time, assuming everything was approved, and then you would come back into the U.S. at that point as a lawful permanent resident. So that would be the way to take care of that situation. There's some other situations that are specific to K3s, which you should be aware of. Let's say that you have a child that comes in on a K4. Okay, the K4 itself does not fall under the Child Citizenship Protection Act. So if that child ages out, that child will be out of status, or you will have to switch from a K4 to an F1, or depending on the education, an H1B. How do you protect the child under the Child Citizenship Protection Act? Well, bring them in on a K4, and then have the petitioner, which is the U.S. citizen, file an I-130 for the child, and therefore that child is now protected under the CSPA and is a child for all intents and purposes until the green card is issued. That's a great, really relatively easy way of getting the child under the CSPA. Another thing you have to worry about is whether or not the I-130, which of course is part of the K3, has been approved. If it has been approved, then many of the consulates will not look at the K3 anymore. They will just go forward with consulate processing. However, the law says that the I-130 must be approved, and it must be sent to the consulate of where it is you're going to be doing the processing, in order for the K3 no longer to be valid and to go forward with regular consulate processing. So if you were to have that case and were to notify the consulate that you do want to go forward with the K3 because they have not received the actual approved I-130, even if it has been approved, then you should notify them and go forward, because again, it does take quite a bit longer for consulate processing to go forward. With the K3, a couple things. You can do a K3 at wherever it is you got married. So if you don't happen to want to go 10,000 miles to go marry your spouse, and you want to meet halfway somewhere, let's say France, you go get married in France, and then France has jurisdiction over the K3. Okay, so that's where everything will be filed to eventually bring your spouse in. The documentary requirements for the K3 are very similar to a K1, being, there has to be the medical examination, the police certificates, the public charge documents are required, and so forth. And as far as the Walsh waiver for K1, meaning if your spouse committed some sexual crime with a minor, that of course applies to K3 as well. If there is a criminal history of the U.S. citizen spouse, even though you may not need a Walsh waiver, that would be disclosed during the process. They just want to make sure that if you're coming in from another country and you're marrying a U.S. citizen, that you do know what you're getting into, at least criminally speaking. As far as the admissions and extensions, generally speaking, K3s are admitted for 2 years. Okay, they're admitted for 2 years, although it's rare that you would have to use all 2 years, because normally what happens, you come in on the K3 and you file the adjustment of status, and way before that 2 years comes about, you will be a lawful permanent resident. Now, you may travel, of course, with a K3 or K4 outside the country. You don't need advanced parole, but if there's something you do that makes you inadmissible during your stay outside, you will not be allowed in. Generally speaking, unless it's an emergency, I would just come in, do the adjustment. When you file for adjustment, then get advanced parole and go out of the country. There's different ways of doing it. Okay, and so with the K3, Another interesting issue is if the petitioner dies. Okay, if the petitioner dies, then the I-130 is automatically converted to an I-360, which is a widow petition, and then they can adjust based upon that. And the question becomes, if there was an A4, what happens? Well, the K4 can accompany or follow to join once basically the I-360 is adjusted and approved. Okay, and so those are some of the issues that come up with the K3s, which you need to be aware of. And again, the most pressing issue which people are unaware of is that when they come in on a K3, things don't work out. They will not be able to adjust. And given that there are a couple exceptions, that apply here. For example, and there's some issue whether or not some officers agree with this, but I've had success in the past. For example, if someone becomes a battered spouse, they can file a VAWA application upon which they do not need. They can adjust if it turns out that they have an asylum claim or a convention against torture. In those particular instances, the United States would not forcibly return you to your home country in order, because the K3 won't allow you to adjust. So there are different grounds upon which you can go forward should you not be on the K3, but 99% of the time you will need to go to your home country, and the new provisional waiver is a great way to minimize the time that you would have to go back. Okay, if you like the videos, click like, click subscribe, and go ahead and give me a call or email me.